Some of you may have heard this past fall about the controversy of Ayn Rand announcing her conversion to Christianity. She was, of course, previously a noteworthy atheist activist, so it was a bit of a scandal when she announced this. What were her reasons? Well, in a piece that she wrote in November explaining them, she said, "The West is under assault, there's a moral vacuum, and only Christianity can serve as a bulwark against the forces of illiberal wokeism and militant Islam." The reason she thinks only Christianity can do it is because she thinks all of the distinctive values of the West come from Christianity, including the value of individual rights. In that same piece, she said the following: "All sorts of apparently secular freedoms of the market, of conscience, and of the press find their roots in Christianity." These, of course, are individual rights. And she doesn't just assert this thesis, she cites a noteworthy historian who allegedly defends it, Tom Holland, who wrote a book called Dominion: How the Christian Revolution Remade the World. And he argues for this very thesis. He says, the evolution of the concept of human rights, mediated as it had been since the Reformation by Protestant jurists and philosophers, derived not from ancient Greece or Rome, but from the canon lawyers of the Middle Ages. Canon lawyers are those who studied canon law, the church law of the Roman Catholic Church. So why think this? Are they right? If not, why not? It makes a great deal of difference if they are. After all, our values are under assault, and we need to know who are the defenders of the rational values of the West. Is it Christianity? Or is Christianity more on the side of those militant Islamists? If Christianity is the correct account of rights, well, then rights come from God, and that makes a great deal of difference over how we think about what rights we have, what they are. Just think, for example, of the abortion controversy. If we think about rights in Christian terms, the fetus has a right, but the woman does not. That's part of the reason I'm interested in this question. As you know, I write on that topic. So we'd better find out, is it really true if Christianity is responsible for the innovation, the revolutionary concept of individual rights that makes the West so distinctive? Part of what makes Holland's argument at least semi-plausible is that, in fact, this is a concept that originated in a period when some of the greatest thinkers on the subject at least nominally identified themselves as Christians. Figures like John Locke. We'll talk a bit about him today. Nevertheless, I'm going to argue that individual rights is, in fact, a secular concept developed by individuals who just so happened to be Christian in many cases, but it did not derive from Christianity itself. I'm going to argue for this thesis by doing three basic things. We're going to first do a brief review of the concept of individual rights. What is its essence? We'll then look at the best case that someone like Holland and his sources could give for why it's a concept that comes from the Middle Ages. We'll look at various medieval views of rights. And then we'll look at the actual revolution that happens in the Enlightenment using Locke as our representative. And the reason to do this, I should note, by the way, is not just because we want to oppose the thesis of Ali and Holland, which I think you can tell I disagree with. But I also think in the course of doing it, we're going to get a better grasp of the concept of individual rights, what it really means. And that is something that we need to understand if we're interested in defending it. Okay, so let's start with a review of the essence of the concept of individual rights here with the assistance of Ayn Rand. And I want to start, a good place to start on a topic like this is with a definition. Her definition of a right. And here it's understood she's talking about individual rights. We'll see why. A right is a moral principle defining and sanctioning a man's freedom of action in a social context. What I want to do for the next 10 minutes or so is to take this definition, break it down into three basic components, comment on them, drill down a bit, because when we turn to the section surveying these medieval theories where rights allegedly originated, according to Holland, we want to be looking for, are these hallmarks of the essence of individual rights actually present? So right is a moral principle defining and sanctioning a man's freedom of action in a social context. Let's start, or we should always start, in a definition with the genus, the wider class that it's a part of. A right is a kind of moral principle. Rights are moral principles because they're concerned with guiding our actions toward other people in a society. They're things that we ought to respect, that we ought to protect. That's the guidance they're offering. So if we think of the rights of Hank Rearden in Atlas Shrugged, the looters ought not to steal his property. The government ought to protect his right to that property. He ought to stand up in defense of his rights. These are ways in which this concept provides moral guidance. An important contrast to make here is with the concept of a purely legal right. So we do speak of rights that are encoded by the law, whether or not they are just. So for example, even if Directive 10-289 says Rearden has no right to intellectual property, it's possible to say, well, but Rearden really does have this moral right, and that law is unjust. As Ayn Rand says, the concept of individual rights is about subordinating might to right, the might of the law to a moral code. Rights are a moral concept that concern defining and sanctioning freedom of action. I'm going to pause on this part, especially to think about what it means to sanction something. Now, hopefully most of you were here for Dr. Gatte's talk earlier in the week where he talked about the concept of moral sanction, a very important concept in objectivism. And it's being used in the exact same sense here. To morally sanction something is to morally approve of it. To say it's good, it's admirable, it's worthy. And rights are all about protecting something that is regarded as morally worthy. Why is freedom something to sanction? Why is freedom good? Not just as an end in itself. Freedom is good because of what freedom allows, because of what it enables, what it makes possible to happen. So we want to protect Rearden's rights to trade freely because we think that what he's doing is good. We think thinking and producing and trading and profiting are morally admirable. And that freedom is necessary for these because, of course, the mind works by choice. You can't force it. You can only destroy it. You need freedom because it enables these good, morally virtuous activities. This idea is made especially clear in Ayn Rand's nonfiction, where she says, this is the concept of rights preserves and protects individual morality in a social context. That's in Man's Rights. So it's about making it possible for someone to be morally virtuous. Here, an important contrast is the view that rights are morally neutral. This is the view that many libertarians have. Libertarians think to have a right to something is not in any way to form a moral judgment about one object of that choice or not. This is part of the reason why they think political philosophy can be detached from moral philosophy. But in the objectivist view, and I think in the broader tradition of individual rights philosophy, that's not the case. There is this moral sanction of a positive activity. I should mention that especially because there are critics of the doctrine of individual rights who think that the libertarian view is the correct view, and they criticize the concept of individual rights for that. They say, well, why wouldn't we want to bring morality into our assessment of a social political system? Individual rights must be nonsense if they're just morally neutral. But they're not. The overall takeaway here is that the concept of individual rights depends crucially on a moral code. And part of what makes it a concept of individual rights is that it's an individualist moral code. We admire Rearden's productiveness and independence because these are individualist moral virtues. Last of all, rights protect and sanction man's freedom of action in a social context. This is the part of the concept that should make it especially clear why this is a concept of individual rights. Freedom is always freedom to do something and from something else. We've already talked about how Reardon's right to property protects his ability to think and produce and trade and profit. That's what it's protecting, but it's protecting him from something very specific. It's protecting him from physical force. He's got the freedom, he should have the freedom to act on his mind, to be free from force. He should be able to use his own independent individual judgment and free from other individuals in a social context who want to interfere with it. This is to be opposed to another view of freedom, a mistaken view from the perspective of individual rights that says freedom is about being free from want or being free from sin or other kinds of metaphorical obstacles. But if the proper contrast is between freedom and slavery, if a slave is someone who is unfree, he's unfree because he's hindered by force, because he's shackled by force. Individual rights are individual rights because they allow individuals to live separate lives from each other, separate from the forceful interference of others. So that's my survey of the essence of the concept of individual rights. And what we need to turn to now is to think about where does this concept come from historically? That's, of course, the claim that Ali and Holland are making. They're making a historical claim that it comes from the Middle Ages. And so let's take a look at the best case they have or could have to offer for this thesis. If it turned out that a bunch of monks living in a cloistered monastery really did come up with this theory, well, I mean, that would be prima facie evidence that Christianity had some influence. I mean, who's more serious about Christianity than medieval monks? But I think, as you'll see, especially if you keep in mind these hallmarks of the theory of individual rights we've just surveyed, the evidence that Holland and his sources have to offer for this claim are just inexcusably weak, and they really betray a misunderstanding of the very concept of individual rights. There are two basic figures or sets of figures that are cited for this argument that I'm going to talk about. And if it was the medieval canon lawyers who are supposed to have come up with this concept, well, the first place you should look to is the most famous medieval canon lawyer. This is Gratian, who lives in the 12th century. And I said the canon law is the body of church law. Gratian wrote a book called the Decretum, and his followers who studied this book are called the Decretists. It's a book that comes up in the context of the West's rediscovery of the body of Roman law around the time of the 12th century. And at this point, these medieval thinkers are basically flummoxed and embarrassed because they're looking at this systematic code the Romans were able to come up with in these pagan times, and they're looking comparatively at their own church code, and they're embarrassed because it's a mess. It's just a bunch of contradictory decrees that have been issued by popes down through the centuries that are filled with all kinds of contradictions. And so the Decretists, the canon lawyers, want to try to systematize, eliminate the contradictions. They say, of course, none of them are real contradictions. They want to show they're just apparent contradictions. Gratian sets himself to this task in the Decretum. How is he going to sort things out? Well, the major alleged innovation here is to bring in the concept of natural law. That's a term he gets from the Stoics, who are not Christian. But the idea here is natural law is to be equated with divine law, with the commandments and the prohibitions of God. Then there's a problem because, well, which commandments? If you go to the Old Testament, there's 613 of them. Are they all supposed to be natural law, especially if we now have a New Testament that's supposed to replace the Old? Well, I guess not. So how are we to sort out the ones that are still applicable? Natural law. What is natural law and how do we know it? Well, we know it because it's instinctual. We know it because it's written on our hearts. they say. That's borrowing language from St. Paul. It's known by all men in all nations. And if we know what the natural law is, we can tell which civil and legal laws are just, which ones aren't. Another alleged innovation that happens in this period is the fact there's more language concerning the rights of separate persons. Previously, when philosophers would speak of right, they would speak of right in the abstract. The Latin term is jus, I-U-S. So they would speak of right as in rightness. They would not speak so much of the rights of persons, like the kind of right that you can exercise or claim, or the right that can be violated by one person transgressing another against another. And so in this period, there's a lot of language of popes claiming their rights against emperors and vice versa, or lords claiming their rights against vassals, or husbands claiming their rights against wives. One of the Decritists in this period, Huguccio, claims that a poor man has a right to sustenance from a rich man. Why? Well, because in times of need, the rich man has an obligation, has a duty to provide him with sustenance. After all, God gave the earth to man in common. And therefore, there's a right to sustenance. Not just rightness in general, it's a right possessed by this poor man. Last major alleged innovation in this period is the idea that there's a further dimension to natural law. It's not just commandments and prohibitions. There's also the things that natural law merely permits. So for example, divine law, natural law, doesn't say anything about whether you should or shouldn't acquire private property. It doesn't forbid private property, and therefore you have a right. It's a bit like, it reminds me of the scene in Fiddler on the Roof where they ask the rabbi, "Rabbi, is it a sin to dance with a girl?" And the rabbi says, "It's not exactly forbidden." So, by that standard, there's a right to dance with a girl. That's what Gratian and some of his followers said. Now, a second figure and school that's influenced by the canon lawyers is William of Ockham. Ockham's a noteworthy philosopher. He's the one with the famous razor. I don't think his razor is used, though, in the following argument. You may be surprised to learn that there's allegedly innovation in thinking about individual rights that happens because of a controversy among Franciscan monks. Ockham himself is a Franciscan. And if you know anything about Catholic orders, which I don't know why you would, you know that the Franciscans are the ones who are especially adamant about their vow of poverty. So the Franciscans take a vow to renounce all private property. They renounce their rights to all private property. And a question comes up in this period. Well, if we Franciscans are renouncing our property rights, does that mean we're renouncing all rights? Like, does that mean we don't have any right to use any stuff? I mean, we still have to run our monasteries. We have to brew our ale or whatever it is that monks do in monasteries. And Ockham wants to argue, yes, even though we renounce property rights, we still retain a kind of right to use. And we can argue for that, says Ockham, if we make a nice distinction. We distinguish natural rights from legal rights. So when you renounce your property right, you're renouncing a legal right, but you're not renouncing your natural rights, the rights that come from the law of nature. And God doesn't think that we should kill ourselves. He doesn't think that we have a duty to preserve ourselves, and so therefore we still have a right to use stuff. And Ockham gets into a bit of a fight with other church members at this point. In fact, there's a controversy between him and the Pope, Pope John the 22nd. For reasons that are too maddeningly complex to explain, the Pope disagrees with Ockham's account. He thinks that if you reject your property rights, you reject all rights. Ockham's very upset about this. He actually accuses the Pope of heresy. He accuses the Pope of trying to violate the rights of the Franciscans. And as a result, he launches a more general critique of papal authority. He says the Pope is a tyrant. The Pope should be subject to secular authority. And he argues against absolutism in both cases. He says even the emperor doesn't have absolute rights. And so there's a sense here that Ockham is speaking up for the rights of the Franciscans. and against tyranny. So what's the case here? That the idea of individual rights came from the Middle Ages. Here's how I would summarize the overall view. They invoked a kind of independent moral standard by which you could evaluate laws. It was a standard that was used to resolve conflicts among parties, which included individuals. Because of that idea that rights are a kind of permission of natural law, there's even this idea, there's a kind of freedom involved. You're free to acquire property as long as you're not sinning. So is this actually a theory of individual rights? I don't think so. And I hope you've already started to see why, in light of what we've had to say about the essence of the concept of individual rights. I have 4 observations to make about this case, about this religious apologist's case, that it comes from the Middle Ages. The first should be the easiest point, the most pedestrian point, which some of them still miss. Not every right of an individual is an individual right. So if we're talking about the right of the Pope against the emperor, or vice versa, yeah, okay, it's true the emperor is an individual and allegedly has this right against the Pope. That doesn't mean he has an individual right. It's not a right that he has in virtue of being an individual. It's a right he has in virtue of being the emperor. And incidentally, imperial rights usually entail the violation of a lot of individual rights, as I would imagine you'd guess. So an individual right is a right you only have in virtue of being an individual. If it's because you're a member of the Franciscan order, that is not an individual right. We should even think, and we will shortly, about that alleged right of the poor man to sustenance. That gets us to our second point. As you've probably noticed from this controversy about the Franciscans, they actually rejected the idea that property rights were important. But property rights are a paradigm case of an individual right. They thought property rights were unnatural. They thought property rights were there only because of the fall. Because man sinned, he became evil, he inherited the sin of Adam, he wanted to kill his brothers. Property rights were there to sort of protect against that. Occam himself thought property rights were an infringement on the natural right of use, because, of course, in fencing something out for yourself, you're taking it away from others. This is why almost every Christian thinker in this period thinks that it's justified for the poor to steal from the rich, because they're just taking back what God gave them in the first place as a matter of natural right. This isn't an individual rights view. This is a social welfare rights view. It's not too surprising, then, that in that passage I read to you from Tom Holland, that he calls it human rights, which is always a code word for socialist rights. And it's why Tom Holland also champions the fact that Christianity was the root of socialism. It's not too surprising, because Christianity's never been individualistic in its metaphysics. Christians aim at the afterlife, where your soul departs your individual body, loses its identity, and in their language, becomes one with the body of Christ. That's not an individualistic view. So much for Ayn Rand's idea that Christianity is the source of the freedom of the market, as she puts it. Property ownership's a paradigm individual right. If it doesn't sanction that, it doesn't sanction individual rights. The way I'd sum up these 2 points: individual rights concern individuals' need to live separately from each other and to use their minds to do that. And a religion that holds faith over reason and selfless sacrifice over self-interest is not in a good position to uphold individual rights. But 2 more points, and with each of these, I think it's especially going to help us get a better understanding of what the concept of individual rights is all about, by contrast. I mentioned that right to sustenance that Huguccio advocates for. And he does it by saying, hey, the rich have a duty to feed the poor, therefore the poor have a right, as individuals. But the way I would formulate what's wrong with thinking of this as an individual right is to say, individual rights are not just shadows of selfless duties. Think about what's doing the work in this example. What's doing the work is the Christian idea of the morality of selfless sacrifice, the duty that you have to give up. The fact that we can speak of the beneficiary as having a right here is really just notational shorthand. And if you think from the perspective of the individual, of the beneficiary, it's not like Christianity says he has a right to the pursuit of happiness. At most, he has a duty not to die because God is the Lord of life. Or think about this example. There were a small number, maybe one classical, there was one classical thinker who thought it was a sin to hold slaves. All the rest of them were fine with it. Ask me more about that if you're interested. But if you said, for instance, it's a sin to own a slave and concluded someone else has a right not to be enslaved, what's doing the work here is the idea of sin. And in fact, when this comes up, it's all about why holding a slave is a selfish, prideful form of existence. It's all about the sin of the master. It's not about the fact that the slave is an end in himself with a right to the pursuit of happiness. It's just not part of their view. So the overall point here is they're not just shadows of duties. Individual rights flow from the importance of the virtue of the one with the rights bearer, not from the fact that there's some duty to selflessly sacrifice on behalf of the person who's supposed to respect rights. One last point about why this is not a theory of individual rights. Again, that will help get a better grip of what the concept really means. Individual rights are not mere moral permissions. Remember that idea, if it's not forbidden, it must be a right. Take the example that I worked with. It's not forbidden to gain property, and they say, therefore, well, you have a right to gain it. Saying something's not forbidden is a kind of moral indifference. It's saying it doesn't matter really whether you do it one way or the other. It's, you're not violating any commandments. Individual rights are not about the indifference of morality. They're about sanctioning moral action. And if that doesn't convince you, think about this example. If you're a slaveholder, you might very well give permission to your slave to use your stuff. If you have a pro-slavery morality, like Christianity, it might even be permissible for the slave to do that, morally speaking. The slave does not have any rights, or they're not recognized and they're being violated in this view. So summing this up, individual rights are there to morally sanction individualistic activity, not just to tolerate it as not violating any commandments. And they sanction freedom from force, not freedom from sin, which is really all this permission idea is talking about. You don't have a right just because you're not sinning against an arbitrary moral code. So I had a section that I cut here on how I do think there's some progress that happens in the Middle Ages in political philosophy, and why the progress that happens actually comes from the Greeks and Romans. If you're interested in that, ask me about it later. I also had a section I cut on the Renaissance, and I think that there are essentially no developments in the concept of rights in the Renaissance. They're essentially the same concepts as we have in the Middle Ages. There are some developments, though, especially in their thinking about slavery. Ask me about those if you're interested in. What I want to move to now is the difference between the Middle Ages and the Enlightenment, the stark difference, skipping over these centuries. Something that you might object to in my presentation so far is to say, well, Ben, you've argued that the Middle Ages don't have theories of rights that exhibit these hallmarks of the essence of individual rights as Ayn Rand defines it, but maybe that just means that only her theory of rights fits this definition and nobody else's does, in which case that would be kind of an uninteresting conclusion from a historical perspective. That's why it's important that there really is a revolution that happens in the Enlightenment, and why a figure like John Locke, why his theory of individual rights really does have each of the essential hallmarks that I talked about at the beginning of the talk. And that's what I want to show in the time that we have left. And his theory has these, even though he is himself nominally a Christian. So I want to argue that his theory arises due to the secular elements in his philosophy, not from anything about his, as we'll see, pretty weakened and watered down version of Christianity. So let's go through those same hallmarks and see how they come out in Locke in a way you would never see in the Middle Ages. So first of all, he definitely thinks that the concept of rights is a moral principle, and in this way differs even from others in the Enlightenment, like Hobbes, who thinks that rights are licensed to do anything you want to anybody else, and that's why the state of nature is nasty, brutish, and short. No, Locke really thinks it's wrong to steal and plunder and a violation of a moral principle. He thinks that the concept of rights comes from a kind of natural moral law. But very importantly, Locke rejects explicitly the traditional view of what natural law is. In an early essay that he wrote in the 1660s called Questions Concerning the Law of Nature, Locke repudiates the traditional view that was held by Gratian and Thomas Aquinas and others that natural law is something that's an innate instinct written on our hearts, known by all men. Locke is just too much of an Enlightenment philosopher to fall for something like that. He's so widely read in history, in travelogues, that he knows and can't avoid knowing about the major disagreements that human beings have about morality. And if they have these disagreements, wouldn't you expect them to agree if it was really something innate? This is, as you should know if you know anything about Locke's philosophy, fully continuous with his epistemology, as argued for in the essay concerning human understanding, where he comes out against innate knowledge. And the chapter on innate, there's no innate practical principles, is basically taken from that earlier 1660s work. And there's another important difference about his view of natural law that distinguishes him from the traditional view. His view of natural law is that it's knowable by reason, and particularly as applied to the senses. Some of the older advocates of natural law talk about reason, but it's never reason applied to the senses. It's reason grasping some self-evident principle. But Locke, again, continuous with his epistemology, thinks all knowledge comes from the senses. Now, unfortunately, Locke doesn't really explain how our knowledge of morality is supposed to come from the senses. I have to say, overall, his moral philosophy is pretty muddled. But one thing I can say about his view here is I think it's important that his view of natural law, which is still in his mind connected to God, is that God creates human beings with a certain function, a certain purpose. And I think, according to Locke, we can discover that function through our own first-handed observations and figure out what's right or wrong on the basis of it. Ask me more about that if you are interested. I have some speculations. So we're already in a very different universe when we're basically rejecting the faith of the traditional view of natural law and saying morality in some way comes from reason as applied to the senses. We're in the realm of the Enlightenment, the realm of a scientific worldview. Let's talk about his view of how rights define and sanction freedom of action. This is about, again, holding a certain kind of activity as worthy of protection. And indeed, he thinks the purpose of government is to protect rights. Why? What do they protect that's so good? I said that he thinks God creates us with a certain function. What's the function? Well, in his second treatise of civil government, where he defines his theory of rights, he's the most explicit about what that function is. He says, God gave the earth to the industrious and the rational. And he means each of these explicitly. The line comes in the chapter in the second treatise on property. And we know what he thinks about industriousness, because throughout that chapter he explains how property is created by using your labor to add value to things found in a state of nature, where there's scarcely any value to begin with. In this respect, he's very different from the traditional view. He doesn't think that the state of nature is something that existed in some Edenic past. Indeed, Locke thinks the state of nature still exists. It exists in America, where there is no government, which is still being settled, where things can still be taken out of the state of nature. There's nothing in this chapter about the idea that property rights are some kind of band-aid against our original sin. There's nothing about how our labor, having to work, is a punishment for original sin. He clearly admires, as a good thing, industrious activity. And government is there to protect that. Likewise with rationality. Locke's an Enlightenment philosopher. He admires reason. He explicitly says in the essay concerning human understanding that God basically wants you to be rational. He wants you to pursue evidence. You have a duty to only believe on the basis of your evidence. God wouldn't give you a mind if he didn't want you to use it. He thinks you have to have evidence even to believe in God. And if you're going to accept any things that you claim are messages from God, you have to be able to prove that they're coming from God. I mean, this is believing in reason as opposed to faith. He explicitly rejects what he calls enthusiasm, which is believing something just because you have a feeling that it might be true. He clearly admires rationality. He wants it to be protected as a matter of right. That is an Enlightenment view. I should also mention that Locke thinks self-preservation is central to the idea of rights. You see him talking about it throughout his account in the second treatise. Now again, Locke does think there's some connection between rights and natural law and some connection between natural law and God. But he very explicitly, in that Questions Concerning the Law of Nature essay, says there is no conflict between following God's law and seeking self-preservation. It's an interesting question why he thinks this. He doesn't make it clear. I have a hypothesis. Ask me about it if you're interested. The important thing is I don't think it's just because he thinks that God will reward you with bliss in the afterlife if you follow. It's a reward that you get on earth. Last, and this is, I think, the most important subpoint here. When you look at some of the most radical rights that Locke speaks up for, they are implicitly, if not almost explicitly, egoistic, in stark contrast to what you would expect from the Christian morality of self-sacrifice. In his first treatise on civil government, Locke critiques the divine right of kings. He says, Adam's descendants have no authority over each other just because they are descended from the first man. And having set that up in the second treatise, he argues for the individual right to revolution against tyrants who trample upon our rights. This is, of course, the view that famously influences the American Revolution. And this is in stark contrast even to many figures in the Enlightenment. If you think, for example, take for example the instance of Hugo Grotius, the Dutch jurist, an Enlightenment figure who in many ways his theory of natural rights influenced Locke. But even Grotius doesn't believe in a right to revolution. He thinks we alienate our rights to the sovereign, and even if he becomes unjust, we don't have a right to disobey him. Not so according to Locke. Locke has the view you would expect of someone with self-esteem. Think about the kind of self-esteem it would require to revolt against your king on the grounds that your rights have been trampled upon. It means standing up for your rights, not bowing down in humility like medieval monks were famous for doing. Last, about what makes Locke so revolutionary. And this is the part that should really bring out the individualism of his view of individual rights. To have an individual right is to be free to do something and free from something else. And here, Locke is explicit in his agreement with the objectivist point that individual rights require freedom to act on your judgment free from force. When he talks about property rights, he makes clear the only thing that violates property rights is violence. And again, property rights are such a paradigmatic example of an individual right. They literally sometimes draw boundaries around our lives when they identify someone's property, essential for allowing us to live separately as individuals. And I say freedom from force against the body and mind, because if you know anything about Locke, you also know he wrote a small pamphlet called Letter Concerning Toleration. And this is the essay in which he argues there is an opposition between force and mind. He says you cannot force a mind. The sovereign cannot compel someone to believe anything. Thus, there's no point in trying to force them to adopt a certain religion. He argues for protecting people's right to disagree with each other about religious matters. The idea of intellectual freedom is so essential and distinctive to the idea of individual rights. If you don't have this, you don't have the concept. And almost no one else before Locke argues for this. Certainly not in the Middle Ages, when they were still busy putting heretics up on stakes because of their allegedly illicit religious views. And the second and last point about the importance that Locke attached to freedom of action. Locke even had the glimmerings of the importance of the metaphysical issues that underpin our need for freedom. So it's worth putting on the table that there are places in the second treatise where he talks about the fact that God owns mankind. And that's why man doesn't have the right to dispose of his life or of the lives of others. But then in the very next paragraph, he'll say, and the basis of property ownership is self-ownership. Man owns himself, and therefore his labor, and that's where property comes from. There are scholars who try to reconcile these apparently contradictory statements. If you're interested to hear about how they try to do that, you can ask me. I think at the end of the day, it is just a contradiction. But it's interesting how between these two contradictory views, the one that Locke really emphasizes is the self-ownership part. That's what he writes on about ad nauseum. And whatever he means by God's ownership of man, he means something pretty modest. Because in the issues in metaphysics that count, you don't see the typical views of the Christians. There's a book that Locke wrote late in his life called The Reasonableness of Christianity. And the very first thing that he does at the beginning of The Reasonableness of Christianity is to reject a core doctrine of Christianity. He rejects the doctrine of original sin. He says, just as Adam's authority doesn't bestow a divine right of king, so Adam's sin does not get inherited by Adam's descendants. A just God would never permit such a thing. We are each responsible for our own sins. So whatever he thinks and means by God's ownership of man, he doesn't think that God owns us in a way that sets us up inevitably for success or failure. That idea, original sin, a distinctively Christian idea, is also usually the biggest barrier for Christians' understanding of the concept of free will. How could you have free will if God is basically operating your choices by remote control? And if you look again to the essay concerning human understanding, Locke has a pretty good view of human volition. He says at various points that our freedom consists in our ability to act or not, our ability to think or not, which is getting in the right direction of identifying the basic locus of human free will. My view is that John Locke developed his theory of individual rights in spite of his, let's say, extremely diluted version of Christianity. He believed in reason over faith. He believed in self-ownership over original sin. And he believed in a kind of morality of the pursuit of happiness as against Christian selfless sacrifice. That's pretty diluted Christianity, if it is Christianity at all. And by all accounts, Locke, in his later years, was a Unitarian who rejected the idea of the Trinity. Again, how can you be a Christian or even much of a religious person if you're a Unitarian who just says there's a kind of clockmaker God. The other thing to say in defense of this is that Locke was also an individual, a real independent individual whose views were not dictated by a set of views that he claimed to believe. And so when there were contradictions in his system, it's interesting how he chose to emphasize one side of it over the other. And he did it on the basis of his own independent, first-handed observations of the world. Locke is an Enlightenment philosopher. He's reading about the problems of the world. He's reading about the colonies in America. He's thinking about how that property is going to be apportioned. He's making fresh observations and helping us to form a new concept that we need to be able to deal with it. He was a practicing scientist himself. That's how scientists think. So I put in the program notes this line from Ayn Rand, and I want to repeat it here because I think we've now seen the evidence of it. The concept of individual rights is so prodigious a feat of political thinking that few men grasp it fully, and 200 years have not been enough for other countries to understand it. But this is the concept to which we owe our lives, the concept which made it possible for us to bring into reality everything of value that any of us did or will achieve or experience. I think you can now see that some of those who do not understand the concept of individual rights are these religious apologists, like Ayn Rand and Tom Holland, who claim that individual rights comes from the Middle Ages. They do not understand this concept. They do not understand how religion and all of its Christian manifestations today are much closer to the Islamists they're trying to defend against. And it's not just religious apologists who don't understand it. Too many secular people don't understand it as well. I hope that I've helped you to understand it a little bit better, because if you care about everything of value that any of us did or will achieve, you need to care about and understand the concept of individual rights. It's a concept infused with morality, there to protect and preserve the morality of individuals. And that's why it enables the creation of so many values. Thank you.
Okay, so individual rights don't come from Christianity or the Middle Ages. But what about the people who would say that it came from the colonists and the founders of the United States? That individual rights as they conceived it was based on the rejection of Christianity and the embracing of a new religion that they explicitly named in the Declaration of Independence, the religion of nature, the laws of nature and nature's God. Is that something that also must be answered?
Well, I guess I don't fully understand the question because there's so much influence that Locke has on the American revolutionaries, and much of the language that you just quoted, they're getting from him. So, I mean, I certainly think it's true that the Americans are operating on a premise of individual rights that is not rooted in religion, but I think it's because they're getting it from Enlightenment figures like Locke.
I suppose it's just that people today would defend that the founders did accept Locke, but they needed God to do so. They needed God and the laws of nature and nature's God to defend individual rights. You could not have a secular interpretation.
Well, if they think that, they actually agree with Locke. I mean, I mentioned this. I mean, Locke still thinks that rights in one way or another come from natural law. And I think this is just a contradiction on his part. But what's interesting about him is the way that he is, when he has these contradictions, he's siding more with the stuff that he gets from his own first-handed observation. And he interprets it in light of the remnants of his Christianity. But for all kinds of reasons I talked about, I don't think the guts of it, I don't think the meat of it could have come and did come from Christianity.
Thank you.
We have a question from the online audience. So Stephen Paplinsky asks, is there any significant descent of Aristotle's idea of natural justice to Locke's or other Enlightenment ideas of natural laws?
Yes. And this is one of the things I hope somebody would ask me about. I mentioned it because in connection with the idea of how does Locke think that we derive knowledge of morality from the senses. I don't know so much about Aristotle's idea of natural justice. I don't actually remember Aristotle using that phrase. He talks about the nature of man. And one thing that's interesting, at the beginning of that older essay of Locke's that I mentioned, Questions Concerning the Laws of Nature, one of the things that he does is to quote from Aristotle's Nicomachean Ethics. And specifically what he quotes is Aristotle's human function argument, where it said, man has a function, his function is to be rational, man operates well when he functions according to reason and deficiently when not. And that's part of the reason I think that when Locke says we know of the natural moral law through the senses, part of what he's thinking about is, well, what is this function that God gave us? And it's something, by all evidence, he thinks we can figure out about people without having to get it from some revelation. We observe human beings and what distinguishes them from other living creatures. And that's relevant to what counts as good or bad for us. And that's an idea it looks like he's getting from Aristotle, and it's one of Aristotle's better ideas in ethics.
Sorry, I was thinking about what you were saying. Fascinating talk. Thank you so much. My question is with regards to objective morality. In your opinion, do the ends ever justify the means?
Yes, if they're good ends.
And if they're bad means?
Well, I agree with the idea that Ayn Rand defends, that what it is to identify good or bad means is to define them with regard to the end. So in her view, the end of morality is individual human life. Man's life is a rational being. And the major means are the moral virtues. She thinks virtues are means to the end of values, values of reason, purpose, and self-esteem. These are the values, she calls them the cardinal values, that in effect constitute what it means to be a rational being. And so the means to that end are rationality, productiveness, independence, pride, justice, honesty. And so the end of human life does justify those means, but it depends very much on the nature of the end. And when people ordinarily talk about the ends justify the means, what they mean is any old arbitrary end that you happen to pick, or maybe some utilitarian end, like the greatest good for the greatest number of people. And those are just the wrong ends. There's no rational justification for them in at least Ayn Rand's view.
And just a quick follow-up question. Does that mean that, like Marx's idea of the utopia, that the utopia is in fact bad, not just the means that it would take to get there?
Absolutely. One of the standard examples that Ayn Rand usually gives when she is arguing against the idea that there's some split between theory and practice, that while Marxism is good in theory but bad in practice, she says, no, it's bad in theory because the Marxist theory is from each according to his ability to each according to his needs, which is the idea of selfless sacrifice, which has, again, no basis in rationality.
Thank you.
Hi, huge fan of Locke, so I thoroughly enjoyed this. Thank you. You gave examples of thought leaders turning to Christianity or moving to a tribe, basically. Do you think they're evading out of convenience because secularism and reason are failing to deal with threats in the world today, like Islamism? I think that's a driver, but I'd like to hear your perspective on that.
I think that secularism is failing to defend a rational moral code, and I can give all kinds of examples of that. I have written about this extensively. Nevertheless, even though that sort of makes it understandable why somebody might equate morality with religion and take refuge in religion to find morality, it doesn't really excuse it, especially not for people like Ayan Hirsi Ali and Tom Holland, who are sophisticated intellectuals and who ought to know, and who do know, that philosophers, secular philosophers, and not just Ayn Rand, have offered rational defenses. And to simply glibly say, well, there's no secular morality, therefore we better go with Christianity, is just overt mental laziness.
Thank you. Thanks.
Hi.
Do you have any other examples where Locke explicitly rejects Christianity? And does he ever make commentary on the work of the medieval monks?
Well, he doesn't explicitly reject Christianity. He, like I said, there's a book, The Reasonableness of Christianity. He's trying to defend his own version of what he calls Christianity. My point is that he rejects explicitly many core doctrines of Christianity to the point where it's no longer clear why he's a Christian, even though he himself says he's one.
Do you have examples aside from the rejection of the original sin?
I mean, I think I highlighted the biggest ones in the talk, and I could probably come up with more if I had a few more minutes, but they're not springing to mind right now. But the ones that I highlighted in the talk are really big, right? Reason as opposed to faith, self-ownership as opposed to original sin, morality of happiness as opposed to sacrifice. I mean, he still thought Jesus was a guy who was kind of cool. I guess he liked Jesus. In that sense, he's a Christian, but not if like the standard is what the New Testament advocates for, especially as articulated by St. Paul.
Any commentary from him about what the medieval monks had done?
Yes. Not any of the ones that I mentioned. I don't think he comments on Gratian or Occam, but the main thing that he does talk about is why he disagrees with their conception of natural law. And he's very explicit in that essay that this is the traditional kind of scholastic view that many of these monks actually held.
Thank you.
Mm-hmm.
Hello. Thank you for the talk. I'm going to take your bait and offer and ask, who is the only classical figure to oppose slavery?
Yeah, thanks. In that same book by Tom Holland, Dominion, he dredges up probably the only pre-Renaissance Christian of any note who comes out against slavery, this Eastern Greek figure named Gregory of Nyssa. And it's true, he gives one sermon explaining why slavery is a sin. And there's two things to say about that sermon. One is the thing I already said. It's just filled with why it's prideful and selfish to have slaves. It doesn't say anything about the rights of the slaves or why they're people who are pursuing their own individual interests and we should respect that. Nothing about that. The other thing about Gregory of Nyssa is that he's influenced by the earlier Christian thinker Origen, O-R-I-G-E-N. And Origen's basically a Neoplatonist who then was denounced by the church as a heretic for basically rejecting original sin. Origen and Gregory both thought it was possible to seek moral perfection. And I think if you look at any actual Christians in that period, but even in the 18th and 19th century who are advocating against slavery, the one thing they all have in common is they are all heretics in the same respect. They all reject original sin. This is true of the Quakers. It's true of John Locke. And many other Enlightenment figures. One of the major things they rejected was original sin. You can't think that we should crusade for moral perfection and eliminate this major corruption in our society, slavery, if you don't think perfection's possible. You'll just say, hey, we're all sinners. I mean, Augustine says slavery is justified by original sin. He says that because we're all sinners, we need to be restrained from each other, and it's better to be a sin to man than to be a sin to slave. That's right there in the City of God. And the light is flashing, so I guess we are out of time. I can definitely take more questions later on. Thanks, everybody.